Welcome back to the county seat. Our topic today, of course, is House Bill 148. It's generated a whole bunch of controversy and conversation, and to discuss it and the topic, we have Mark Ward, who is the Public Lands Attorney for the Utah Association of Counties.
Hello.
Thanks for sticking it out with us for this period of time. Representative Mike Noel, who represents several of the counties in southern Utah. Mike, good to have you here.
Good to be back with you again, Chad. Appreciate all you're doing in this area. Appreciate it, your abilities to get this out to the public.
And first time on the county seat, Representative Ken Ivory, and it's been a delightful conversation so far.
Thanks, Chad.
All right, let's go back and let's talk about, okay, now you've got to prove up this bill. Now, when the bill was introduced, it went through legislative analysis, and they said, you're going to have problems with this bill. Can we address some of those problems?
You know what's really fascinating about that? The case that they cite, this Gibson case, it's a disposal case. It's a case where the federal government disposed of the land, and the language that they cite is 3 generations down the line, where there's a title issue, 3 generations down the line. But they don't dispute the fact that the federal government has to dispose of the land, and then they don't even cite the Hawaii case that's less than 2 years old. So their very case speaks to this duty that the federal government has to honor, this trust duty, this promise to dispose of the land.
That's true. You know, Hawaii is probably the most recent precedent that would really apply here.
And you know, back to this, I don't want to keep talking about disposal because that's not the purpose of this bill. This is an education equality bill. This is to bring our state up to the same level as other states in the East, and we think we can do it with this. We think we can generate much more income off these lands. Let's take a look at our forest projects. You know, the Forest Service is in the Department of Agriculture because they were supposed to be producing timber for us. They have stopped producing timber because of NGOs that have sued them on every account. They would rather see the trees get eaten up by bark beetles and die and rot and create problems for private property adjacent to them with the urban interface and fire that's out there. Let's look at the grazing program. They've shut down our AUMs on public lands. They made it very, very difficult for ranchers and farmers to use those lands at a time when cattle prices are at historic highs, when cattle prices here in Utah are at historic highs, and we could generate that income on those lands. The mineral resources, which right now, just through severance taxes, through mineral oil and gas leasing, not even talking about the jobs, is $250 million to $350 million. We think we can 5 times that. We are the Saudi Arabia of energy in this country. We have oil shale, we have oil sands, we have coal. We can do all of those things, generate income, take care of our schools, higher education. We can do that, Chad, if we can be in charge of our own destiny. If we can be a sovereign state, like was promised to us in the Declaration of Independence and the Constitution as we came together, that we were going to unite together and be a state. We formed the federal government for that purpose, and we did not give up our sovereignty nor autonomy. We want to get back to that. We want to take back Utah, and that's what this bill is all about, and the other bills that are running in the state legislature this year, have run in the legislature this year.
Well, what about the pros? I mean, I don't want to keep coming back to this, but you know, we had the list of the cons. Is there really good support for this bill, historical?
Oh, historically, absolutely. Absolutely. You go back and trace the history from 1780, the original compacts from the states when they were in the middle of the war and said, we've got all this land, and there was actually a fight over whether or not they could even confederate. And they said, okay, look, we'll take the land and we'll give it to the federal government as trustee. And from 1780 to the Lands Ordinance of 1785, to the Northwest Ordinance of 1787, to Article 4 of the Constitution, to Andrew Jackson and his statement in vetoing a bill that was going to change the trust compacts, to Supreme Court cases all the way up to our admission, where they call this a sacred trust. The trust obligations that once the federal government has executed these trusts will be on equal footing with our lands, and our municipal sovereignty will be complete. Then to our Enabling Act, which is the exact same terms of all the states east of Colorado, where they say they're going to extinguish title to all the lands. No, the history is very, very clear. And then you've got the Hawaii case that says Congress does not have the right to change those vested rights of our Enabling Act, those rights at statehood. So that's all we're looking at, Chad, is we just want you to honor the same promise you made with all the states east of Colorado.
You know, regardless of whether people agree with you or disagree with you, Representative Ivory, you have definitely demonstrated a very clear point that you've done your homework on this bill before you put it in, because these are very solid arguments.
You know what's interesting? When I was in law school, I had a professor that said, you know, if you get stuck, just think of what the right result should be. If you think about who we are, we fought a war to get away from a land baron. That's what King George was. You control the land, you control the people. We fought a war to get away from a land baron. Does it make any sense at all that our Constitution in any way would open the door for that confederated government, that union, to be a land baron? Well, of course not. So you start there, and now you go back to look at the history and say, how did we get here? Well, obviously we got off the track because the history bears out that we never did authorize a land baron, but that's where we are now. We were supposed to have multiple use sustained yield. For most of our land, it's no use, no yield, and it is our children that suffer. $2 billion away from average in per pupil funding. We're $4 billion away from states that do control their land on a per pupil funding basis.
You know, Chad, it's interesting. People have argued, we actually had a little argument on the House floor that said the only equal footing doctrine that they're talking about is political equality. And I made the point, and I think it's a very good point, just as Ken just made, if you control the land, you control the people. Now you look at what's happened in Utah because of the fact that we do not control 2/3 of the land, that we have a federal overseer that's taking care of this land. What has it done to the private lands? What has it done to us politically in Congress? When you have people in Congress like Maurice Hinchey that's passing a bill to lock up another 9 million acres of land in a special designation. That totally flies in the face of the Federal Land Policy Management Act that said we were going to have multiple use and sustained yield. You were going to receive half the resources. You would own the roads. You would control the water. You would have the grazing. You would take care of all these. You could have the forest, and you could have all these receipts that would come into your state. They've taken all that away. Politically, economically, we have been totally corrupted or co-opted on this situation when we do not have the rights that we would have politically in Congress because we don't own the land. We don't have the economic power and we don't have the political power. So they're wrong on that issue. And let's go back to a couple of people, Bill Howell and Bill Redd. Bill Howell and Bill Redd were the ones that started this whole issue. Bill Howell was the one that brought this particular issue forward, this case in Hawaii, and brought it to our forefront. They wrote a book called The Territorial Initiative. They have fought this. There are people out there that have pushed this agenda, and now, again, some of them are taking over the reins. They broke trail for us. Ken's going to be there. Others that are out there that are fighting it. And to tell you what, we've got the governor behind us on this thing. We've got the governor of the state of Utah. For the first time in the last 4 governors, we've got a governor that has stood up, said we're going to take the money and we're going to give you the money to fight this. He's fighting us on with our road help. We have a great opportunity this time. This is a very, very important time in history for people to recognize, and they need to help us. They need to support us. If you want to get our state back and get our economy rolling and take these receipts in, you've got to stand up for this issue. You've got to support us on it.
Mark, you're like a judge hearing a case over there in the corner. It's just...
Yeah, I think I'll take it all under advisement. No, just kidding. Yeah, the pros on this, the county's perspective, if you don't mind, a little bit on this. Local governance is always the best governance. Time and time again, this is what counties have learned. People who are closest to the land are going to take better care of it than someone who's, across the country. Counties are reeling from the back and forth policies that come down from one administration to the next administration. Counties just went through an 8-year process to develop land use plans on BLM lands that culminated in 2008, the last few months of the Bush administration. We've seen nothing but disruption of that under the new administration, and it's draining. It's a drain on taxpayer dollars. We need stability. And counties know this idea that local folks don't care about the land. How absurd is that? I mean, if people just need to count to 10 backwards and think about that. You're telling me the people who live off the land, the people whose land it's their birthright, all they want to do is ravage it? That doesn't make sense. It's time for everyone to count to 10 backwards and think outside the box. This idea that federal ownership is the only way to go is like my kids say, that's so 20th century, Dad. I mean, we need a new paradigm. We need a new way to look at it. And that is, the wall that needs to come down is this notion that the locals don't know how to take care of their land.
That's interesting you brought that up, Mark. You've been to King County many times, Chad. You've been over the state in rural Utah. You've been to my ranch. You've watched as I cut hay. You've been right there. 130 years. in the settlement of Kane County. It's been 130 years until they created a national monument. We did such damage and destruction to those public lands that it was eligible for a national public monument, or a national monument. Isn't that something?
Yes.
Bryce Canyon. We actually petitioned for the national park in the state of Utah because we saw the uniqueness of that area. Zion Canyon. All those areas were people that lived on the land, took care of the land. So you've seen that. You've been out there in the country. Do we destroy the land? Do the people that take care of it manage it?
I think that that's been an axiom for years, that the best conservationist is the guy who has to live off of his land. We'll continue this discussion here on the County Seat program. We appreciate your joining us. We'll be back in a few minutes with one final segment. Stay with us.